lovely to have you here, and hello everyone, and welcome to everyone. It's great to have so many of you joining us from such a broad range of organisations, bringing your diverse experience and expertise to today's discussion. For those of you who don't know me, I'm Sonia Law. I'm the manager of Victoria Legal Aid's Mental Health and Disability Advocacy Program. And I want to kick off by acknowledging and paying my respects to the traditional custodians and caretakers of the land that I'm joining from today, the Wurundjeri Willem people of the Kulin Nation, and pay my respects to elders past and present, recognising that all of us joining the session today, wherever we are joining from Aboriginal land where sovereignty was never ceded. And I want to acknowledge the continuing strength and resilience of First Nations cultures in the face of a history of dispossession and discrimination, and also acknowledge how much there is to learn from First Nations perspectives of social and emotional well-being that incorporate connection to family, community, country and spirit as essential to mental health and well-being. And I also acknowledge and welcome any First Nations people who are joining us for this event. I've just got a bit of housekeeping to make you aware of. Obviously, we've got at this stage, I think we've got the technology gods smiling on us. I'll just take you through how we're going to do this. It's a Zoom webinar. So that means all of you joining as audience members, your microphones are muted automatically and speakers can only be heard. So please use the chat function if you have any difficulties with tech, and we'll do our best to assist you. And if there's any general discussion or information you want to share with the audience generally. But we're going to use the Q&A function for questions. So if you've got questions for the panel, please make use of that function. The event's being transcribed live, and for those who need it, we can also take questions via a phone call if you can't use the Q&A function. And the number for that is 0417 396 149. And I'll share that number again when we start the panel part of the session. And just reminding you that the session's being recorded. Before we go any further, I'd like to introduce Auntie Di Kerr, our Wurundjeri elder, to welcome us to country today.
Thank you. I honour my ancestors and my elders, and I pay homage to the sacred ground I'm on and all of the sacred grounds you're all on. I wish to acknowledge any Aboriginal and Torres Strait Islander peoples. I acknowledge all elders and elders of different nations, any First Nations peoples from across the waters, and I acknowledge you all and I pay my respects to your ancestors, elders and families. It's an honour and a privilege to be able to be a part of your journey today and to be able to welcome you all. And thank you for inviting me. And mental health is my passion, as we were talking about before. And I wanted to share a little story, and I hope that I haven't shared it before, and if I have, I'm sorry. But we have a few years back had a lot of our young girls that were struggling, and we found that they didn't fit in the mainstream area of mental health, which we call emotional health and wellbeing. And as elders, we felt that we were failing them and we didn't know what to do. So myself and my sister and a niece decided that what was missing in our lives and their lives was ceremony. And we started doing coming of age ceremony, contemporary, with them. And we still have continued now for, I don't think it's 7 years now. And it was amazing. And it was very emotional. And it was 185 years since that ceremony had been done. And they had to make their own outfits, burn their possum skins with their stories, make their own jewellery, which is the reeds from the creek. And we put them through ceremony, and we had younger ones, and they assisted the girls. Normally, in old times, the girls were presented to the men of the tribe. But of course, we don't live like that, so we presented them to family. Both male and female. They became very strong women, and out of the 20 women that turned up, we thought we'd just have a handful. 3 of those girls were cutting themselves, and they've become very strong, and they're now mentors for our younger ones. And they have formed their own dance group, and they dance every day. And they sing in language, and they dance very tall and proud, and their connection to country is very, very strong. And when the first time we did it, and we go on a Friday, and they do ceremony on a Sunday night, and we talk to them about being an Aboriginal woman and what is needed, and we don't allow them on their phones until over night time. And now when we go, and it's once a year, we don't even have to tell them not to have their phones, and we sit around and do cultural activities, and we don't even give them what to do, they just do. And I think that in itself is powerful, when we're just sitting around and they're making their skirts, or they're weaving, or just enjoying life. And my sister and I know that we've done the right thing. And now we do baby naming ceremonies, and those girls welcome the babies and then do a celebration dance after the babies have gone through ceremony. Because ceremony was taken from us when my grandmother was born on a mission called Corrandirk Station. Ceremony wasn't allowed. And I think that's what's missing in our lives. And it's caused a lot of mental health issues for us, and a lot of deep sorrow and hurt. So it's just a little story I wanted to share, because I believe that when you're dealing with clients, you need to think about what's missing culturally in their lives. And I know that I go to a lot of hospitals and psychiatric hospitals and do ceremony and do smokings and assist in that cultural way. And I believe in having special ceremonies, regardless of what culture. If they have a ceremony, they should be allowed to do it. And people should understand that sometimes that's missing in their lives, and it does affect their mental health. And those things that you can't see physically is what's missing in their lives. So I hope that you think about that. So, just a small snippet, and I hope it wasn't too long. And I want to thank you for allowing me to share that. So I just want to say to you, all of you, may Bunjil, my creator, surround you all and give you strength and resilience, and particularly for those of you that are in Melbourne, like myself, that are locked down. And, I think it's going to be our lives for a couple of years. And instead of getting angry, we just have to, praise our creators that we're safe, and try not to think the angry way. So on behalf of my elders, I say Womanjika, Wurundjeri Ballak, Yuman Gundibik. That means welcome to Wurundjeri country. And all of you are zooming into Wurundjeri country, but you're not on Wurundjeri country, but I hope that you get that strength and feeling from my welcome. So Nun Godjin, thank you for allowing me to come into your meeting this morning.
Thank you, Auntie Diane. I was waiting for Sonia, but I think I'm meant to step in. So thank you very much for that. That welcome. We've already had some posts in relation to that very personal very instructive for us, but I can see that image of those young women dancing tall and proud, and it is such an emotional image. So it is one that will inspire us to do the things that we need to do, not only today in this session, but more generally. So thank you so much for sharing that with us. I too would briefly like to acknowledge the owners of the traditional lands on which we're all meeting and pay respects to elders past, present and emerging, and note that their lands were never ceded. I'm down on Wathrong lands near Geelong, and every day when I have an opportunity to look out at the sea and the water, I think of our First Nations people and what their lives would have been like in this amazing environment down here. So great to have so many people attending. I think we've got about 260 people online, which is an amazing turn up and is a statement of resilience itself, given how much we do this by Zoom. So wonderful to see people here. I'd particularly like to welcome all our lived experience experts who are online and people with lived experience who have taken the time to get us to this point, but also to be part of this particular engagement, to share and consider the important work that we need to do. There are many people on this line who hold a particular role, and I do want to mention a few of them because it's important, I think, for us to know how significant this event is in terms of the role holders who are with us. I'll get a chance to introduce Catherine Wetton, the DepSec in Health, who'll be speaking to us shortly, but just wanted to also mention the Mental Health Complaints Commissioner, Treasure Jennings, the President of the Mental Health Tribunal, Matthew Carroll. I'm very pleased the President of the Law Institute of Victoria has joined us too, Tanya Wolfe. Of course, our panellists, Maggie Toko, Chris Malia and Dr. Karen Rubin. VLA board members are also online, which I'm pleased about because we're all in this together, in my view. George Habib, thank you very much for attending. Andrew Saunders. Also the chair of the new expert advisory group for the new legislation, the new Mental Health Act and Wellbeing Act, Michael Gordon has joined us, and Dr. Margaret Grigg from Forensic Care, who many of you will have seen in the media over the last couple of weeks. So thank you to all of you for your attendance, but once again, particular acknowledgement to those with lived experience. If I could name every single person on this line, I would, to thank you for your attendance here today and for the contributions you're going to make. So I'd briefly like to say how exciting this point is to be at in our lives. I think Victoria has taken an amazing first step in having the Royal Commission report. It is certainly an ambitious report. Well, there's several reports, of course, and many volumes, but if I think of it, it's ambitious, it's exciting, but it's exactly what's needed for the systemic reform we desire to see here as a collective group here in Victoria. Can I say the reports focus, the multiple reports focus on compassion and humanity, and the way in which that report reflected the lived experience of people who gave evidence and their poignant experiences and sometimes terrible experiences in our mental health system was really wonderful to see. And I think the report captured that very thoroughly, and it makes me proud to be a Victorian to have seen that from this particular exercise. From VLA's point of view, we are very supportive of the lived experience voice and of people being able to help design and craft what success looks like into the future and how that's experienced. The perspective of clients and consumers, and indeed the work of our IMA advocates, is very important, not only from a rights perspective, but to ensure that we actually get things right. I understand thoroughly what, as a lawyer, but also as someone who's done a bit of this work in the past, what big legislative reform looks like. But particularly, I understand the challenges of translation from a report and implementation, and my own involvement with the NDIS and the NDIA, now coming up to, nearly a decade ago, but for 4 years, really is a testament to me of the importance of consumer voice. And even today with the NDIS, of course, we see the consumer voice very thoroughly out there all the time, because it holds governments to account, it holds us all to account to make sure that what is designed and delivered actually meets the needs of those who live through these experiences many days of their lives. I think the realisation of our vision and the embedding of cultural change that the Royal Commission envisages very much depends on consumer involvement and that experience. So I want us to take that message and hold it dearly for however long this journey is that we're on. So with those few words, I would very much like to welcome Catherine Wetton. Catherine, of course, is the DepSec in the Department of Health, who is responsible overall for these reforms. It is a massive job, but also a great privilege, I think, for you, Catherine, to hold this role. It is one of the sorts of projects, if I can call it that, that will, I imagine, be defining for you, just as it will be defining for Victoria, and most importantly for those that use our mental health systems here. So thank you for being available for this, and I'll hand over to you.
Thank you very much, Louise, and it's really wonderful to be able to be here today. I'm just checking, I can see the slides have gone up on the screen. I'd like to acknowledge the traditional owners of the land on which we meet today and pay my respects to elders past, present and emerging. And I acknowledge and pay my sincere respect to any First Nations people who are joining this forum today. And thank you also to Auntie Di for that very moving welcome to country. I'd also like to recognise all people with a lived experience of trauma, neurodiversity, mental ill health and substance use or addiction, and their families, carers or supporters. This recognition extends to the clinical and non-clinical workforces that support people with lived experience. And as I said, it is a real pleasure to be here today, and great that so many people have been able to join today. I am here to talk about the Mental Health Royal Commission's recommendations, also a little bit about the 21-22 Victorian State Budget for mental health, and then what this means for development of a new Mental Health and Wellbeing Act for Victoria. And after I talk, there'll be a panel discussion that follows. Next slide. Thank you. So before I talk about the Act, I did want to briefly revisit what has led us here today. So if we go back to October of 2018, the Victorian Government committed to hold a Royal Commission into Victoria's mental health system in recognition that the existing system was broken and that many people were missing out on vital care and support. And so we've known for quite some time that things weren't right and that we needed a plan for action that would help drive reform across the mental health system. And so in November 2019, the Royal Commission handed down its interim report with 9 immediate recommendations highlighting urgent and critical actions that were needed. And the government's 2021 budget committed $571 million towards those initial actions. And that work is really well underway now. It includes the rollout of new HOPE services, and that's the aftercare service for people following a suicide attempt, acute and hospital in the home beds, and also some workforce expansion as well. And then, as we all know, the Royal Commission's final report was tabled in the Victorian Parliament in March this year. The final report does set out an ambitious and transformative reform agenda spanning 65 recommendations. And really, it is the tireless work of many people who made submissions, who met with the Royal Commission and have advocated for years for a better system. And this is a number of you who are here today. So the Royal Commission could not have covered the breadth and depth without those efforts and voices. So we are very thankful for all of those contributions. Now, we certainly have our work cut out for us in the coming months and coming years, and this is certainly a long-term reform journey, but it is truly an exciting time for mental health and for this once-in-a-generation reform. And it is important that we keep reminding ourselves too that the government does support and has committed to implement every recommendation out of the Royal Commission. So it is a 10-year reform agenda though, and we are getting started on some of the new actions that were recommended in the final report. And so some of those are the first 6 of the adult and older adult mental health and wellbeing service priority location sites have already been announced across the state. They are to be in operation from mid-2022 and by the end of 2022. And then there'll be additional services that come online in the coming years. There's also early foundational work that's beginning on development of a new statewide workforce strategy and also a new Mental Health and Wellbeing Act, and I'll come back to the Act in just a minute. And we are just at the beginning of this work. We have a very complex and significant reform journey ahead of us, and the work program is expansive. The importance of lived experience is a prevailing theme across the Royal Commission's report, and we're absolutely committed to placing people with lived experience at the centre to design and deliver services. And we also know that the Royal Commission's vision cannot be realised without you and the people on the call today. So we really need your engagement and your support as we steer through this reform process over the coming years. So if we can go to the next slide. Thank you. So the magnitude of the reform outlined in the Royal Commission's final report, it is going to take time, and therefore we're working on a staged approach to implementation. And we really need to balance the scale of reform and the ability to have that authentic work with our partners, but also then with the urgency of needing to tackle some really big current challenges in the system. And the government has said that each successive state budget will fund reform based on that 10-year program of work. And we really are just at the beginning of that. The 21-22 state budget is a very good beginning though, and it marks a real turning point in building a new mental health and wellbeing system. And it has that record investment of $3.8 billion over the coming years. The budget for this year, it is a combination of investment for new initiatives, new activity and new infrastructure, and it is a significant increase on previous budgets. Next slide. Thank you. So now I would like to talk briefly about the work that's being undertaken to develop a new Mental Health and Wellbeing Act, and I know you'll all be very interested in this. So the Royal Commission recommended that the Victorian Government repeal the Mental Health Act 2014 and enact a new Mental Health and Wellbeing Act, with a new act to be in place by mid-2022 to provide the legislative framework for the new system. And while this timeframe is very ambitious, and a number of people keep reminding my team and me of just how ambitious that timing is, given the time it takes with other big legislative reforms, we do believe it's possible to do in the timeframes, because the framework provided by the Royal Commission has got quite a bit of detail to it, and many of the recommendations in the report go to the things that would be in that new act. I'd like to acknowledge that the Royal Commission's recommendations about how to strengthen our legal framework were based on the experiences, feedback and advocacy of many people, including many people who are here today. And the objective of achieving the Royal Commission's very ambitious legislative reform agenda will be supported by one of the recent budget announcements, and that's $7.73 million to develop the new Act and for supporting services. So the Department of Health is undertaking work now so that the Royal Commission's recommendations are appropriately reflected in the new Act. And this will include seeking submissions on topics where additional inputs required that will give full effect to the Royal Commission's vision. And I'll come back to that process shortly as well. Next slide. So in reviewing the final report of the Royal Commission, the advice was very clear that the system needs to shift to encompass good mental health and wellbeing for all Victorians. To achieve this, the Commission has set a strong and ambitious vision for the new Act too, and you see on the slide there, to promote good mental health and wellbeing for all Victorians, to reset the legislative foundations for the mental health and wellbeing system, to support the delivery of services that are responsive to the needs and preferences of Victorians, and also that puts the needs and preference of Victorians with mental illness or psychological distress first. Next slide. And then looking at the scope of the project, the timelines are very ambitious, but again, as I said earlier, we do think that they're achievable. So to assist with this process, the department established an expert advisory group to support the design and delivery of the new Act following the Royal Commission's report in March. And the expert advisory group includes individuals from diverse backgrounds that incorporates lived experience, human rights, legal and non-legal advocacy, health law, health service governance, and clinical mental health and community support service delivery. And we're really, really grateful for the work of that group, and it has been a pretty intensive process so far, and really, really appreciate all of the efforts from those members. We'll also soon be commencing public engagement, and that's going to include a couple of things. So release of an update and engagement paper inviting feedback on particular policy proposals for the new Act, and that will be via the Engage Victoria website. And we're expecting this process to commence shortly during June. We've had a minor delay with COVID lockdown, but hoping that that will start very shortly during June. It'll also include some targeted consultation with stakeholders on the detailed policy development required to translate the Royal Commission's recommendations into law. And then following this engagement process, the policy for the new Act will be refined and settled based on what we hear through those processes, and the approval and drafting processes for Parliament to consider the bill by mid-2022 will begin. Next slide. Thanks. So the Royal Commission emphasises that the Act can enable good practice and new service models and encourage a human rights-based culture to flourish. And the role the law can play, I know that those on the call today will know this, but the role the law can play in supporting efforts to reduce restrictive practices and compulsory treatment is also emphasised by the Royal Commission. The Act will establish the new system governance and oversight entities which embed lived experience, such as the new Mental Health and Wellbeing Commission and also the regional mental health and wellbeing boards. And the Act is just one part of the work to deliver on the Royal Commission's recommendations for a new system. But as we know, that legislation is and should be a powerful tool for change. Next slide. So proposals to address the Royal Commission's recommendations will be provided in that Mental Health and Wellbeing Act update and engagement paper that I mentioned just before. And so engagement, you can see there on the screen, engagement's focused on implementation of the Royal Commission's recommendations in the most effective way. And that's focused on the objectives and principles of the new Act, non-legal advocacy, supported decision-making and information sharing, compulsory treatment assessment, seclusion and restraint, and also governance and oversight of the new Act. Next slide. Thank you. And so here, what I've got here on the slide, there are some questions that we need to answer as we take the Royal Commission's recommendations to law. And so I won't go through all of them, but just you can see there some of the questions really. How can we ensure that the Act, or how can the Act ensure that the objectives and principles reflect the Royal Commission's aspirations for all Victorians? How can it ensure that supported decision-making is promoted through all stages of a person's assessment, treatment and recovery? And how can the Act ensure timely access to opt-out non-legal advocacy? So, and that compulsory treatment is only used as a last resort, and accountability and transparency around its use is increased. So, and then finally, sorry, I'll keep going, that the use of restrictive interventions is reduced and ultimately eliminated, and accountability and transparency around their use is increased. And then finally, that new entities, including the Mental Health and Wellbeing Commission, are enabled to fulfil their very critical system oversight roles. So we hope that you'll consider and respond to the proposals addressing these key questions and help shape development of Victoria's new Mental Health and Wellbeing Act. Really appreciate your time today. It's been a pleasure to be able to make some introductory comments before the panel kicks off, and also to be able to update you on progress of some of the significant reforms and next steps for development of the new Act. So we know there is a great deal of interest. Oh, sorry, next slide, sorry. That was good of you to so know there's a great deal of interest in this work, and we're really pleased about that, and we look forward to the ongoing support and the really valuable contributions of VLA and many of the individuals and organisations who are here today. So thank you very much.
Thanks very much, Catherine. And we really appreciate you sharing that information about the process. As you say, there are many eagerly awaiting information about the process around the new legislation. So it's really great to hear from you at this important time, as you say, of moving from recommendations into law, into action. And a huge amount of work went into the Royal Commission process, including from so many people who are joining the call and with us today. And it's now that the real work of system reform begins. I guess that was a penny dropping moment for me, having invested quite a bit of work in the Royal Commission process, to realise when the final report was delivered, it was not the end of a process, but the beginning of a process. I guess I want to take a moment at this stage to particularly welcome anyone with lived experience of mental health issues and of the mental health system who are joining us, and recognise the important work done by people with lived experience in achieving system reform. We certainly wouldn't be here talking about the outcomes of a Royal Commission without their continued advocacy, and the implementation of those recommendations will impact on them directly. And whilst I have a professional interest in it, it's different from having that personal direct interest in this process. And I think it's important for us to keep that perspective centred throughout our conversation today. So VLA welcomed the Royal Commission process and its recommendations, and it's a huge opportunity to improve the system, how it works for consumers, and particularly those subject to compulsory treatment orders, which is where we do most of our work at Legal Aid. The Royal Commission recognised that compulsory treatment is a significant limitation on human rights, and frequently a negative and harmful experience for consumers. And this was something that's been reflected by many consumers who shared their experience with the Royal Commission through the work that we did in the Your Story, Your Say project, collecting those stories. And the Royal Commission also recognised that the reduction of the use and duration of compulsory treatment was one of the main objectives of the current legislation when it was introduced in 2015. And a number of provisions were included to achieve this, such as maximum term orders and increased oversight of compulsory treatment by the Mental Health Tribunal, including in regard to the use of electroconvulsive treatment. However, despite those legislative reforms, rates of compulsory treatment in Victoria remain comparatively high and have continued to increase each year since the introduction of the Act. So reflecting that, the Royal Commission concluded that this should be a focus for the Victorian Government, focus on reducing compulsory treatment, and made a number of recommendations to achieve this, one of which was the introduction of a new Mental Health and Wellbeing Act. And as Catherine has said, good legislation can be a powerful tool to change the system, to enable good practice and new service models, promote a rights-based culture and reduce restrictive practice, as the Royal Commission has stated as the objectives of that new legislation. But legislation alone can't achieve the culture and practice change we need to see for the system to change so that it works for consumers and overcome the problems with the system that the Royal Commission has highlighted. So VLA's mental health lawyers and IMA advocates are based in all of Victoria's mental health services, and we see every day the reality of the mental health system and its impact on people's lives. We know that despite the intentions of the legislation to promote and enable voluntary treatment, the system often defaults to compulsory treatment, and the likelihood of someone being treated compulsorily varies from place to place. We also see variable understanding and uptake of supported decision-making by clinical services. We know that although the same legislative criteria apply across all services for compulsory treatment, the number of orders made varies from service to service. So today is an opportunity for us to hear from different experts so that we can make sure that this legislative reform process addresses these issues, and how we can create the necessary culture and practice change to achieve the vision of the Royal Commission, and what the role is of new mental health and wellbeing legislation to create that change. We're going to hear briefly from each of our panellists before hopefully having a bit of a conversation despite the online format. And we're keen for the conversation to include questions from those of you in the audience. With the webinar function, participants won't be able to use their microphones or put their hand up on video to ask questions. So we're using the Q&A function for you to ask any questions that you want of the panelists. And we'll be keeping an eye on that Q&A, so pop your questions in there rather than using the general chat function, which you can use to share information generally with everyone on the call. The Q&A function also allows you to ask your question anonymously if you'd like to. And for anyone who can't use the Q&A function, you can call through with your question on 0417 396 149, but please just use that if you can't use the Q&A function. Okay, so after all of that housekeeping, we'll move to our panel. So our first panelist is Maggie Toko. Maggie is of Ngāti Whātua and Ngāpuhi descent, Indigenous to Aotearoa. Maggie's proud to identify as a consumer, as someone with lived experience of mental distress and as LGBTQI+. Maggie's a strong and effective advocate for social change, as many of you know, and strives to present a voice of reason in a generation of reform. Many of you would know Maggie through her work in various places, but most particularly in her long-standing and recently completed role as CEO of VIMIAC. Welcome, Maggie.
Oh, kia ora, Sonia, thank you. And your pronunciation was really good. Yeah, you got it right. I just want to acknowledge the traditional owners of the land on which we meet today, the Wurundjeri people of the Kulin Nation, and acknowledge the elders past, present and emerging, and that their land has never been ceded, and that they are in fact the tangata whenua of Australia. I'm passionate about reform because it's an opportunity to look forward to a time when consumers are placed in the driving seat for their own destiny. And for this to truly happen, however, there needs to be actions in place that they, the consumer, can tap into. Firstly, the elimination of restrictive practices within the legislation is a great start to reform, and bringing the opportunity forward to a 5-year wait period would be better, but having it on the agenda is better than not having it at all. The new Act needs to do what the current Act doesn't do, and that is hold services and organisations to account for what doesn't happen. It would be wonderful if the new Act had a platform that provided a robust point of reference that enabled accountability as one of its top measures. I hope that supported decision making is front and centre of the new Act, that advanced directives are seen as a tool that can be utilised by consumers on an ongoing basis, and that it is mandated that every clinician has a conversation with consumers about the benefits of having an advanced directive. I hope that there is a further discussion about the involvement of more than one consumer and one carer on the regional boards, because I think that's just not enough. I hope that there is an opportunity to have a senior advisory committee of leaders who can, of lived experience leaders who can remedy discussion points and provide co-design and co-production principles. I think the lived experience commitment is fantastic. I think there will need to be an ability to engage the employment of lived experience personnel, though, and that be a broad spread across the system. I believe that the lived experience quality expertise provided by lived experience workers will help support the engagement of the new Act once it's designed. I certainly know people who are on that committee working on it, and it's a huge task. It's a full-on job that they have to do, and so and I believe they will get it done by the timeline that's instructed. So I hope that the new Act brings about a reform that consumers are happy to be guided by, that it puts them front and centre to the drivers of the new Act. And I hope that's it's not the best that we can hope for. It's an excellent start that we can hope for. I might just close it there, Sonia.
You're on mute, Sonia.
Was bound to happen, wasn't it? Maggie, you've covered so much ground in those brief comments, and I think there's a lot of meat there for us to come back to around that consumer leadership and lived experience, and also that stuff about accountability of services. So we'll come back to that in our conversation, but move now to our second panellist, Dr. Karen Rubin. So Karen is the head of adult psychiatry at Peninsula Health and deputy chair of the Royal Australian and New Zealand College of Psychiatry's Victorian Branch Committee. Karen has over 2 decades of experience in public and private mental health services, and his areas of interest include general adult psychiatry, psychotherapy and trauma work. Karen has clinical and academic expertise in supported decision-making, recovery-oriented services, co-production and trauma-informed care. Karen is a passionate advocate for reducing the use of treatment orders and the reduction of restrictive interventions whilst maintaining safe and therapeutic hospital environments. Welcome, Karen.
Thank you, Sonia, and thank you, everyone. I'd also like to acknowledge the traditional owners of the land in which I'm sitting at the moment, the Bunurong and the Bunurong people. And I'd like to say tēnā koutou to Maggie for what she said. I really appreciated Maggie. I want to start off with a general overview, which is, as Sonia said, for me, this is just a period of incredible excitement and optimism. We've had a Royal Commission, which is basically saying all of the things that I think are important and interesting and we should be doing are the things we should be doing. So that, for me, I think, there's so much potential for change. My concern is that we had a change of Act 7 years ago, and the Act changed and practice, as Sonia rightly pointed out, didn't change, and things have continued to trend in the wrong directions often, because the real issues are not legislation, that we have funded services that can actually deliver the things that people need. It's about the culture, both within those services, of the way in which they approach and treat people and care, but also the broader culture in which we all live, things that are much harder to change. And then there's those deeper issues that were never really properly addressed in the last Act, that you might change the Act, but if you want to change practice, you need education, you need training, but you also need experiences which change the way people think. And I'm going to talk a bit more about how I would hope that this new Act can embed co-production and co-design more deeply in our systems, probably along similar lines to what Maggie was talking about, that it's not tokenistic and single people, but that it is done in a really cohesive fashion. I'm going to mainly be talking about supported decision-making, but within a context that I think some of the things that this Act is going to have to grapple with are issues around compulsory treatment. And there's a lot of other things, but as somebody who works often at that end where we are utilising compulsory treatment, I think there's a real chicken and egg problem. I think we could significantly, in a very short period of time, significantly reduce the amount of compulsory treatment in our system. But a well-resourced system with diversity of options open to people, I think, is the thing that's really going to make a difference in the long term, so that we are able to make sustained, meaningful changes where people are getting better treatment without compulsory treatment being necessary. I also think those well-resourced environments will certainly help really significantly in the reduction of restrictive interventions. I'm going to talk a bit more about those as well. But I think the Act is going to have to grapple then with issues around capacity. And this capacity law has entered into our previous Act. It's in mental health acts around the country and in other countries. But the problem is that actually the question of capacity is addressed variably. And even if one looks at Justice Bell's ruling around ECT, the definition of capacity that he used, coming back to the Re-C case that people may be familiar with, spoke about somebody's capacity to weigh things, but didn't actually necessarily use the same kind of wording and language that was used in the original judgment. So we enter into all of these areas that, legal experts will often struggle to wrap their heads around. And for the average person with lived experience and the average clinician, it's just an absolute minefield. And so I think the Act is going to have to be a lot more clear about how we understand and assess capacity. But also, I think what is missing from that, even though it's there in the Act, is the understanding that capacity is very decision specific. And that the fact that somebody may be deemed to lack capacity and may be placed on a compulsory treatment order does not mean that they're not able to engage in a supported decision-making process around the type of treatment they would like to have. And I think it's these nuances that often don't get captured well in Acts, and it's how we put those things into practice that is so important. And that's where I come to supported decision-making. It's there in our current Act, and I would have to say that, the research evidence we got says much of the time it doesn't happen, and that we still often have these binary type situations where people are often engaged in some form of shared decision-making processes when they're not compulsory patients. And a number of people, certainly not the rule, but a number of people, as soon as they're made compulsory, people say, well, you're on an order now, so we'll make the decisions for you. And that's not, in the spirit of understanding that capacity is very specific to a time and a specific decision. It's not respectful of people's human rights. And actually, it's not a good way to engage people in treatment that is going to ultimately aid their recovery. So I think we need to be, supported decision-making needs to be really clearly embedded in the Act, and how supported decision-making is not separate to whether somebody is a compulsory patient under an Act, or whether they're a voluntary patient, but supported decision-making has to be embedded across all care. I want to come briefly to reducing restrictive interventions, and this is something where I think an Act can make a bigger difference. And I think, I apologise to, people who don't agree with me, but I think that a large number of the restrictive interventions that we do utilise in our hospital systems can be, if not significantly reduced. I would like to see some of them completely eliminated. There is evidence out there that it is possible, and the things that act against it are actually the under-resourced units, the environments we have, but also some of those cultural attitudes and training. And so I think an Act can be much more specific than our current Acts have been about safety, but also I think, clearer about definitions as well. What are restrictive interventions? Because my experience has been that you work at some services and things are reported as restrictive interventions. You work at another service and they go, oh, that doesn't meet the requirements for being a restrictive intervention. And yet it's the same behaviour. So ironically, I've worked at services that get called up for having high restrictive interventions, and then when you look at it, they're applying the most stringent possible criteria, and other places may look low, but they're saying, oh, that wasn't restrictive, we only put hands on somebody for 10 seconds. So I think these are the things that legislation can help us with. So definitions are important. Final thing I want to talk about is that balance between, risk, people's rights and people's dignity, and the dignity of risk. And I think this is something we've still struggled with, and risk remains prominent in our thinking. And so while I think that we need to be much more nuanced in our understandings of risk, I think we need to be careful about unintended consequences. In that if we move things in such a way that people who really require treatment because of risks of harm, particularly to other people, or aggressive behaviours when people are unwell, we run the risk of increasingly criminalising people, with people saying, well, we can't, provide you with treatment for that, so the only other recourse is that you go to jail. And I'm putting that bluntly, but I think we've already seen that happen to some extent in Victoria. And I think it's an absolute travesty when you look at the rates of people with mental illness in our jail system. It should not be that way. And I think, this is another way in which underneath the radar, people are, being removed from society or receiving restrictive interventions. Final point I want to make, I want to echo what Maggie said. You know, co-production and co-design is not having a token representative person, but it's about embedding people with lived experience and clinical experience, I would add, in all of these structures, because it's in working together that we come up with the practical solutions that we can put in place to make things better for people. We are better together. If clinical practice is not informed by lived experience, we're just going to keep reproducing the same mistakes. So this needs to be embedded into legislation. And I would argue that we need a lot more people with lived experience up and down the system, and we need the clinicians working with them to help enact those changes. So I've probably gone over my 5 minutes, but I can't help myself. I'm too excited about this. I'll be quiet now. Thanks, Sonia.
Thanks so much, Karen. I think a lot of us share that optimism about this process and are keen to make sure that it delivers its potential. So thanks for sharing all of that, which was again also a lot of meat in your presentation. And there's a few things that you've talked about that I'll definitely want to come back and explore further with you in our conversation. But we'll now move to our third panellist, Dr. Chris Maley. Chris is a mental health social worker, lawyer and senior lecturer at RMIT University's Social and Global Studies Centre and the Deputy Chair of VIMIAC. His research focuses on the intersection of health, welfare and law, and he's the author of over 50 peer-reviewed articles and commissioned reports, including research on legal and non-legal advocacy in mental health, gender-based violence in mental health inpatient units, advanced statements and human rights. Dr. Maley is a member of the Expert Advisory Group providing advice, expertise and support to the Department of Health for the design and the delivery of the new Mental Health and Wellbeing Act. Welcome, Chris.
Thanks, Sonia. It's great when you get to write your own bio, isn't it?
Sound great.
That's fantastic. I'm on Wurundjeri country and would like to extend my respects to elders past and present, and also to any First Nations people who are here today. I'm going to take a slightly different track. I don't think anyone invited me on this panel because of my optimism, so hopefully that won't come to any surprise. Won't come as any surprise to anybody. But I have quite a different perspective, I think, on that. I'm going to stick to talking because I was told I was only allowed 5 minutes, and I have a lot to say about the rest of the recommendations of the Royal Commission, but I'm going to focus on the legislation because that's what we're here to talk about. So starting at the point of agreement, everybody from the Premier, the DepSec, to every person who's working in the system agrees that the system is broken, that it needs real change. So many people are getting trapped in this cycle of trauma where they're betrayed by a system that promises to help them. So that it's accepted that this is people's experience, not everybody's experience, but this is the problem that we're trying to address. The key problem, as far as I see it, is that people in the mental health system are not given the same rights as everyone else. You can be in the mental health unit in the hospital and you have completely different rights to the rights that are afforded to you elsewhere in that hospital. Now, the Royal Commission recognised this, it's in the report, but then they failed to do anything about it. And this is a real problem. The recommendations that the Royal Commission have made about the new legislation, they're calling it new legislation. That's a lie. It's not really new. It'll have a different name. Legally, it's a new piece of legislation, but it's essentially the same thing. The key fundamental parts of it will be the same, and that's not the fault of the people who are writing it. I've been seeing firsthand the amazing amount of work they've done and how restrained they've been by the Royal Commission's recommendations. But fundamentally, we are not going to have an act. The new act is not going to be human rights compliant. So leaving aside the international human rights law, which we should never do, but for the sake of this discussion, we have had a Charter of Human Rights in this state for many years, and Section 8 of that Charter requires that we are equal before the law. Now, if I have a physical health issue and I lose the ability to make decisions, then I can write a document, an advanced treatment planning document, and make those decisions for myself, or I can appoint somebody, anybody who I like to make those decisions. In the mental health system, that is not allowed. I can write that document all I like, but nobody has to pay, have to have regard to it, right? So somebody has to read it at some point, hopefully. That's the extent of it, right? It's a very, very different system. The new Act, thanks to the unimaginative recommendations of the Royal Commission in regards to the new legislation, the new Act is not going to change that. We are going to have this same problem with the new Act as we do with the current Act. So this is a real problem for me. The things that the Royal Commission has said the Act is going to do, and that everybody else is saying the Act is going to do, it cannot do unless it is addressing these really basic fundamental rights issues. So the scope is very limited by the Royal Commission. The process is very rushed in terms of bringing in the new legislation. The rushness is not so much the problem, that is again the Royal Commission's timeline that they've set. But even the development of what we're doing now isn't co-produced. So the Royal Commission has said we need co-production in the system, but the development of the new Act isn't co-produced. They have said we're going to have a review of this current Act 5-7 years into the future. We'll see if that occurs, and that should be co-produced. But what's happening now isn't, and that's a real problem. Even the really good bits that have come out of the Royal Commission in regards to the new Act, and I'll pick up on the opt-out advocacy that's been mentioned. Now, people told the Royal Commission something very specific. They said, we really like IMA. IMA is fantastic. I did the evaluation in IMA, and they told me that. I heard dozens of people tell me how much they like IMA. The recommendation is not for IMA. The recommendation is for non-legal opt-out advocacy. They're two different things. And we've kind of missed the point. The good thing here is IMA, right? And what we're ending up with is the potential, anyway, for it not to be IMA, for it to be something different. And so we have to pay a lot of attention going forward, even to the details, even to the good things that look good. Like strengthening supported decision-making is another example of that. Well, okay, how is that going to happen unless it's really about equality, unless it's about my decision when I can be assessed as having capacity, and leaving aside the problems with assessing capacity, but just in terms of equality, if I can be assessed as having capacity, my decision should be respected, and it's not, and it won't be under the new Act either. So that's a real problem. Sorry, I've just got to go back to my list of problems. It's quite long, isn't it? There does need to be a service delivery response, and we hear that. It's almost automatic to say, oh, we're going to have legislation, but legislation can't do everything. We need to do that. Now, that's true. That is true. But it's the wrong way around. Compulsory treatment is the problem. It's not the solution. So we can't solve compulsory treatment by improving the service system. We need to take compulsory treatment and restrictive interventions out of the power of clinicians, out of the power of services, and then we will see the cultural change. While it is still there, we've known this for 100 years. If you read Clifford Beer's The Mind That Found Itself, right? He talks there about how when people who are trying to help you have, this is in 1908, this book's published, when people are trying to help you, if they have these coercive powers, these tools, it corrupts the people who are using them. And this is the problem. So we need to take those powers away. We need equality now. We need at least equal rights with people in the physical health system. We need binding advance statements. We need substitute decision makers. And we need to do these things now, not in 10 years. We need to get rid of restrictive interventions in particular right now. A key player in the new landscape, I was asked to talk about the Mental Health and Wellbeing Commission. Unfortunately, we talk about the new landscape. It's the Mental Health and Wellbeing Commission is will have the same powers as the current Mental Health Complaints Commission, with some data kind of clearinghouse roles as well. That's not going to make the kind of difference that we need to see in this system. We need a much more fundamental change. When they launched the Commission report, the Royal Commission report, they talked about a new road. This is not a new road. We're just paving over the current system. It's going to have the same problems, the same cracks. And if we do want to see real change, we need to maximise the potential for actual reform. And the agenda as it is now is unimaginative. It is not significant enough, particularly in the legislation space, but everywhere. And we are going to be back here in another 10 years saying, why hasn't this worked the same as we were in 2014? Why have all these changes not had the impact that we wanted to have? It's because they're not real changes. They're not fundamental. They are largely cosmetic. And yes, that's my non-optimistic perspective. I hope that was what I was. I hope that's no surprise to anybody. Anyway, thank you, Sonia.
Thanks, Chris. I mean, there's obviously a tension between ambition and what's possible to achieve that's being negotiated here, I guess, and you've got a vision for that real fundamental change to planks of the system that I guess haven't been endorsed by the Royal Commission. So I guess I'm interested in terms of recognising that limited scope. There's a number of, but also recognising that we didn't, the 2014 Act that had a number of changes identified that are being identified now that weren't achieved, like legislative change. I guess I'm interested in what are the lessons from that can be helpful here in terms of what can be achieved given those constraints. Because if we'd had full implementation of what was intended then, we would be better off now despite that limited scope.
Yeah, 100%. If the current act now, then if the current act worked, then it would work. You know, that would. I mean, I think the lesson for me is that we didn't need a Royal Commission to know all the problems with the system. But come on, we've been yelling about them for years, and we don't need the Royal Commission's report now to tell us what's broken. The Royal Commission, it's in the report there. It's just not in the recommendations. The implementation guidance that's been given by the Royal Commission is not going to result in the vision that the Royal Commission has put forward. And so now it's up to government to say, okay, we think you've been a bit too pragmatic here in these recommendations, and we need to, you know, go that extra step further. And the tension that is between that vision and the limitations of the recommendations, we're going to see play out over the next decade. Every step of these reforms, it's going to stymie what we actually need to do.
And you spoke about the difficulty about advance statements that have a role legislatively, but don't actually bind or compel, that clinicians are not compelled to follow, where a person records their wishes for their future treatment, and it's advice rather than required to be followed. There's some interest, I guess, in that in the questions that have come through, and one of the biggest difficulties we've seen with those is that they haven't been taken up at, you know, in great numbers. I'm interested, you know, do you have some solutions about how they could do more work?
Well, I can tell you if they were binding, people would take them up in more numbers. When we did research on this and we asked people why they didn't do them, they said, why? Why would I? I mean, it's to be told, write down what you want to happen to you, and then to have that ignored is worse than being told at the beginning, we're not going to listen to you. Yeah, if you tell me you're not going to listen to me, I can probably process that. This is an adversarial process now. You're not listening to me. You don't care what I think. Good. But to be told, to be given that promise and then have it ignored, that's the betrayal of the trust that I opened with. I'm not surprised that we have this low take-up. What is the point of doing it? Some people do love them. We did when we did this research. It was actually split evenly. About half the people we spoke to, and it wasn't very many people. Half the people we spoke to thought they were great, and it was good that they weren't binding because their doctors knew best and would make good decisions for them. But for the other people, for the people who didn't have that perspective, they're fundamentally pointless at this point. And the recommendations of the Royal Commission aren't going to change that in a way that restores trust in the system.
And Karen, I wonder if I could come to you. You talked about the fact that it's not a binary thing. A person's on an order, they're not on an order, and like if a person's on an order, there's still work to be done in terms of how the person is engaged with and able to make decisions about what happens to them. We've got some interest in the Q&A about how you bring the workforce and the cultural change. How do we help clinicians to get there if they're not there? Oh, I think you're on mute.
Yes, I've been putting myself on and off mute because I've really been enjoying what Chris has got to say, and just itching to also talk about that. I think one of the difficulties around how we use sometimes advanced statements is that binary thinking as well, and saying to people, hey, write down what you want, and isn't that great? And then they get to a different situation, somebody looks at it and go, oh, we're not going to do that. And I think, again, for me, this comes back to the same question about how do we engage people in supported decision-making processes. Part of it is that it is a process of engagement, and it takes time to actually sit down with someone. And I'm going to come back to supported decision-making, Chris, and advanced statements. I sit down with people and say, let's do an advanced statement. But my role in this is not to tell you what you can put in your advanced statement or not, but to help you think through some of the different approaches you might get, because it's not binding. And so I often work with people on, let's put down your ideal. Let's put down if I can't get my ideal, what would I still really like to happen? And let's put down your non-negotiables. And while I can't guarantee that, having a nuanced approach, and I'm really upfront with people about it, that, hey, you might not get what you want, but if we try and do this really well together and put something on paper that at the end of the day you're happy with, that I think should be achievable. If you don't get it, you've got people going into bat for you saying, what are you guys doing? And so I think this is where it's about nuanced approaches sometimes, because a supported decision-making process is not about saying, you tell me what you want to do and that's what we'll do, but it's about helping support people to get to where they want to be at through looking at all of the things. And that's not just around, that's about looking at all those enablers, such as having the appropriate legal support. It's about having family or other, people, substitute decision makers who they've nominated before. And I'd say it was one of the real failures of the last act that it may have had nominated persons. But, if you look at the percentage of people who have a nominated person, it's minimal, and nominated persons are not even used appropriately when they are there. So I think these are where, you put the things in legislation, but they may not make a difference. But I think it's about cultural change, and I think that is about experiential education and training. And so many people know I worked on a co-produced supported decision-making project that had people from IMA involved, people from VMIAC involved, all sorts of people. And when we ran some of the pilots of the training, it was experiential stuff. It was actually about having people think about being in somebody else's shoes. It was about, the training was co-delivered with people with lived experience. There were real scenarios where people were actually presented with what the experience was like of other people in those situations, and they had to think about how they could do things differently. And we were not surprised, but really gratified that we did a 3-month follow-up of this, and people's practice changed. But it wasn't about telling them these are the new regulations or this is what you have to do. It was actually about helping them to understand things from a different perspective. And I don't think you do that in an hour, and I don't think you do that because the legislation has changed. I think it's about changing the conversation between people with lived experience and between clinicians so that we bring things much closer together. And then supported decision making can be done much more easily in an environment where there is actually dialogue backwards and forwards. Again, it's a really interesting question, what Chris said about adversarial systems. There's some good arguments for actually separating out the civil and the treatment aspects, so that the person who is providing you with support care is not the person who's making the decision about whether you're receiving a restrictive intervention, because that creates a tension in the relationship where automatically your engagement in the therapeutic capacity is decreased. So there's a lot of psychiatrists who'd be arguing for separating out the civil and the treatment aspects of this, recognizing that there is always, from my perspective and other people's, there is always going to be a need for some compulsory treatment. But I know that not everyone will agree with that. But at the same time, it puts some people in a really difficult position. How can you trust somebody who has that power over you? The power differentials are huge. So I think, supported decision-making processes also look at how do we reduce power differentials. And when you build those into a system, it becomes difficult. So I think now is the best time to be having these conversations. I'd be also, I'm still positive, but my concern is we're doing this in a rushed way. The Royal Commission and said we need this by now, as opposed to if we want to do something fundamentally different, it may take a bit more time. And look, that's all I'm going to say there. I guess I think there's a lot more. I'm really interested in other people's opinions.
Yeah, I think it's certainly been my experience everywhere I've worked that putting a consumer at the table in the conversation changes the conversation in a fundamental way. And with that in mind, Maggie, I wonder if you'd like to reflect on what's been said.
Hi. Yeah. Well, look. I think both Karen and Chris raised some huge issues around developing a new act. I like the comment that you made, Sonia, which was if they had done the real McCoy with the first act, wouldn't need a second one. So if we know that, why are we going to a second one? Why aren't we just correcting what's wrong with the first one? But we are in the process of going to a second one. So maybe it's about correcting that process from the first one to make sure it's instilled in the second one. But I think the fundamentals are around what Chris was saying, which is like we are our rights as a lived experience person are my rights when I'm at Peter Mac fully implemented, and they are. I can say that from first experience. But if I go to across the road to the Royal Melbourne and I'm in John Cade, am I awarded the same the same courtesy? And the fact is, I'm not. And that's not about John Cade. That's about being under the Mental Health Act. And it just doesn't make sense. They talk about recovery as being a journey, that it's it's a marathon, it's not a sprint. But whose marathon is it? Whose journey is it? It's actually my journey. If I'm the lived experience consumer in question, it's my journey, how I do it and how I would like to do it myself, not how someone else wants me to do it for whatever reason that they think that I should do it. It's actually about, and Chris is right. If I'm not going to be listened to, why bother? Why bother at all? And we're talking about our fundamental human rights, our basic right to have choice and control. And that's just not happening. It's not happening, it hasn't been happening for a long time. And the reform is supposed to bring about, to me, the reform should bring about choice and control, that I can actually choose what my treatment is, if there's treatment at all, that I have options, that I have alternatives to restrictive practices. It's not a hard fit to think about what alternatives could be. Consumers out there are saying quite clearly what they would rather have, that alternative therapies would be an option that they would choose. So why isn't that kind of thing in place? So I am full of optimism. I'm an optimistic kind of person, and I just believe that we will win through in the end. But how many bodies do we have to go over before we win? And we shouldn't have to go over any.
And Maggie, it's part of the Royal Commission's vision to put the views, preferences and values of people living with distress, their families, carers and supporters at the forefront of service design and delivery. Like, reflecting on what you've just said about the need for that to be real, like it not to be a tokenistic thing. Like, how can that, what's your thoughts about how that can happen in this process?
Look, I think I had a few years teaching at RMIT, where I taught social work psychology students, Cert 4 students, And one of the things I would say to them is, you are not the be all and end all in someone's life. In fact, you don't really count. You know, you're there to make sure that you do the right thing. But at the end of the day, those people who support that person and those people who support that person are the meaningful people in their lives. So there was always a question over youth work, that youth workers thought that that young people didn't need their families, that the youth worker would be the be all and end all for them. But in actual fact, families, good or bad, are there forever. So it's, how do we work with that? And some families can't be there. They just can't, because they're terrible. And I've experienced those situations. But there are families who can be there, who are supportive, who do align with what their person says. And it's important to recognise that they can't be dismissed, as well as any, you know, and family is, who's your family? It's significant others. It's not necessarily your blood family. So again, that needs to be taken into consideration going forward.
Thanks, Maggie. We've got lots of questions coming through in the Q&A from people joining us, and some of them reflect, I guess, I feel like some of them have been addressed in some of the comments that have been made so far, but I'll draw on some of the others. So there's some interest in the use of restrictive interventions that can occur in emergency when a person's considered voluntary, and that there's concern about that not being monitored in the same way that it is when it's used under the Mental Health Act in mental health units. And the question is, how could the new Act address this issue? I wonder if that's something you might like to speak to, Karen?
It's a really tricky one, because in a sense, the difficulty is that the Mental Health Act doesn't address this issue because it's covered by a different act. I'm always terrible with names. It's the Medical Treatment Act or something to that effect. And people, I guess those kinds of interventions are used for very different reasons, often in an emergency department. But there can be a lot of overlap. And the problem is that depending on the act on which you're being treated under and who you're being treated by, it does affect those things. So I think that's a real difficulty that we've got. Until somebody is under the Mental Health Act, the Mental Health Act doesn't apply to the use of interventions.
Chris, do you want to say anything about that?
Thanks, Sonia. I'm working on a project at the moment, actually, on emergency departments as a response to distress, to mental distress. And it was really interesting. We interviewed, and it's not published yet, but a good little teaser for you. The clinicians we spoke to talked about a duty of care as the power that they were using to detain people. And it's not quite right. That's not quite what a duty of care means. And so there's this real misunderstanding, I think, of what the law allows in those spaces, and what lawyers, when they're drafting these pieces of legislation, think is going to happen or think happens in that space. So yeah, I think it's really unclear. I think it needs a lot more investigation, actually, because what the policy says, what the clinicians told us what was happening, what the consumers told us was happening, was not consistent with what I don't know, the Supreme Court might say is how the legislation or the common law should be applied. So I think emergency department settings and crisis responses in general, police responses, ambulance responses, emergency department responses in general, and their interaction with the legislation and with mental health legislation and other law is a real question mark. The Royal Commission has made recommendations around that. For example, the police shouldn't automatically or shouldn't always be first responders in mental health crisis. How that's going to look is anybody's guess. How do you tell as a police officer if something's a mental health crisis or not before you get there? or as somebody on a 000 hotline, how do you work that out? And so I think all of these questions need a lot more investigation. And it would have been great if the Royal Commission could have done that. you know, and kind of made some really clear recommendations about how that's going to work. The other thing on Karen's point there is if we didn't have different legislation, we wouldn't have this problem. If we could get rid of the Mental Health Act, we don't need a new one. We could adapt the Medical Treatment Decisions and Planning Act and have that apply across all healthcare settings. And then we have equality before the law. It's actually not rocket science. It just requires political will that we don't currently have.
Just while I've got you talking about restrictive interventions, we've got a question in the chat around your view that restrictive intervention should be abolished and what that would mean in terms of legislative change. So, and also the question of the regulation of chemical restraint, whether that should be covered in the new Act.
Yeah, sorry, as you mentioned at the beginning, I'm on the advisory group. I'm just trying to remember what's in the public domain or not. But I think that's clear that that's going to be in the new Act. The Royal Commission has recommended that chemical restraint be defined. It's really difficult to do because are we talking about the intent of the clinician? Well, I can tell you the clinician's going to say that they didn't intend to chemically restrain someone, because clinicians aren't there to do restraint. They're there to help people and to help people heal. And in the mind of the clinician, if that's where the legal test is, then virtually everything that's done is done as treatment, even if it's treatment to stop somebody harming, somebody else. So the problem is, how do we tell if it's experienced as chemical restraint? And particularly if somebody is chemically restrained, that's going to be a difficult thing to assess. So I think it's a very difficult thing to do. In terms of how we stop it, sorry, in terms of how we stop it, we just take the power away. We get rid of the seclusion rooms, and we have adequately staffed services where people can have their needs addressed immediately. I don't think it's, as Karen says, it's quite clear that it's possible to do.
And so, Chris, I think you've picked up on what for me was, again, one of those head-scratching moments when the chemical restraint, I'd happily say as a clinician, I've never chemically restrained anyone, because what you're trying to do is alleviate distress, reduce agitation, and, what one person, it is intent, and the intent versus the experience of what is done can be really different. And how do you legislate something like that in a manner that's reasonable? You can legislate to get rid of seclusion rooms. And so for me, I'm scratching my head when new units are being built with seclusion rooms still in them. And certainly I know, having sat on advisory panels for building new units, I'm like, right, well, here's some extra space. You get rid of the seclusion rooms. You build a unit that is safe. You staff them adequately. You have quiet places for people to go. You have access to sensory rooms and equipment, but you also have place for people to get out of the environment that's causing them distress. It's all there. And so my concerns is that, the evidence is there, but it's unless we're using the evidence and unless we're funding it. This is expensive. When services are being stripped decade after decade, this is expensive. Supported decision-making takes more time than just making decisions for people. One is good practice, one is not good practice. But when you're in a stress system where you might get 10 minutes to make a decision and move on, how do you spend 2 hours with someone supporting them? The answer is you do. I've run into this as a junior psychiatrist, having to go to my boss and say, look, I'm currently working double the numbers of hours I'm employed for, and I still don't think I'm doing my job well enough. What's the deal here? I'm not spending enough time with people. That's not how the system's been set up, is the problem. So these are the things that I do think need to fundamentally change, because I don't think legislative change is going to address those issues in and of itself. But I think, there is evidence out there. I can point to services. I work, as you said, at Peninsula Health. In the last 6 months, we've had 1 episode of seclusion, and that caused huge concerns for us. Like, why did we have 1 episode of seclusion? Like, what do we need to do differently so that we don't have that 1 episode? Now, that's not completely eliminated, but we're pretty close. And that's consistent. That's not a new thing. It's a service that has been actively working for a decade to do it and has got to that point. So my thoughts are, yes, it does take time, but I would also, like Chris say, I don't think these things can be done overnight, but we should be moving right now to make fundamental changes around the use of restrictive interventions, because I think they do cause trauma for people. I think they're often counter-therapeutic, and they're actually often dangerous for the staff involved in them, for the people involved in them. They don't reduce risk, they just transfer it somewhere else. So, strong opinion there, I know. But I want to come back to my other concern, which is around the legislative burden. And as Chris said, trying to legislate for things that are happening inside people's heads often is remarkably difficult. But the more legislative burden we create, the less time there is actually to spend with people working on recovery, working on supported decision-making. So I think legislation needs to be practical and targeted. Legislate the things you can clearly change. But spending a lot of time legislating something, which just means you'll have to spend more paperwork justifying whatever you did. And as long as you can justify it on paper, people can't say you did anything wrong. Doesn't create a healthy system. And that's my concern. It doesn't actually create accountability. It just creates paperwork.
Thanks, Karen. Look, we're getting very close to time, and I want to apologise to all the people who put questions in the Q&A that I haven't been able to pose. I wonder if we can do just a couple of really quick fire ones, just to. So one is about how consumers can get involved in helping shape the new Mental Health Act. And obviously, we know that there's a consultation process kicking off on Tuesday with paper being released. But Chris, I know that VMAC's done some work in this space as well.
Yeah, so we just next week we'll be launching the Act on the Act report that we undertook with over 200 people who responded, surveys and workshops looking at what changes people wanted to see under the Act. The department has a copy of that. It's not publicly available yet, but we will be launching it next week, as I said. In terms of future engagement, please follow the VMIAC social media. We'll be making announcements as to how we will be supporting people to respond to the consultation paper when it comes out.
And the Q&A, the question in the Q&A so talks about also consumers being involved directly rather than through peak bodies. And of course, that's something that people can do through that public consultation paper and process. So
that will be on Engage Victoria, and people can respond directly. And we would encourage, VMIAC would encourage people to do that as well as sharing with VMIAC as well, yeah.
And we've got a question from Tanya Wolf, the president of the Law Institute of Victoria, about people missing out on legal assistance at the Mental Health Tribunal, and whether there's any moves to make that more readily available.
That won't be a legislative question. That's a budgetary question. I think that's probably a question for you, Sonia, isn't it? In terms of the budgetary position, but I don't think it's going to change significantly in this budget, is it? In terms of increasing, Victoria has one of the lowest rates of representation of the tribunal.
And the Commission recognised that, made a recommendation for increased access, and there's some indication in the budget that might be forthcoming, but the detail's not yet clear. So I apologise to anyone whose questions we didn't get to, but I think it's a reflection of the very fruitful discussion that we've had. It's very timely because so many of us on this call have invested work and hope in this Royal Commission process and want to see the system reform that process promised delivered. And I know that some of us feel like we've been here before and feel that lack of optimism that Chris has expressed and worry about the promise not being realised. And it just highlights, I think, that this next stage of implementation is so vital. We need to continue this conversation and collaboration to make sure we achieve the reform that we know is needed. And not all of that requires legislation. I think a lot of what Karen's talking about ways of working, it's clear that that's happening in some places already. It doesn't need to wait for system or legislative change to happen. So I would encourage you all to feed into the upcoming consultation process on the new legislation when the paper's released next week, and also to get along to the launch of VMIAC's report about what consumers said that they wanted to see in the new Act. And before we finish up, I want to thank Auntie Di for her lovely moving welcome to country today, and Catherine Wetton for her presentation about what's happening in the machine room, and also our panelists, Maggie, Karen, and Chris, for the wisdom that they've shared and the ground that we've covered. And I also wanted to thank everyone who's joined us today for your engagement. So much engagement on the Q&A. I'm sorry we couldn't get to everything, but let's keep the conversation and collaboration going after today, and hope to see you all and continue that conversation soon. Thanks very much.
Thanks so much.